the budget and the finance bill, which has now subsequently been passed, which will very soon get approved, assented by the President, and will become the Finance Act 2023, has come in as a root shock for investors in the debt space, because it has made very drastic changes with regard to how the taxation law was being applied to some of the debt products. And I'm sure many of the people who are invested in mutual funds and who are looking at debt as a very important segment of investment would have to make fresh decisions with regard to how they invest, and whether some last minute changes would be necessary to protect their tax position with regard to their past investments. So many things would be haunting the minds of people who are invested in the debt space. And it's very opportune that you have brought about this discussion. The very unfortunate thing has been a very major change in the system of taxation with regard to debt mutual funds, which has been introduced as part of the final changes to the finance bill, which unfortunately was not even discussed in the parliament, as the parliament has not been functioning for the last many days. It is not entirely the fault of the government, but it's the political process that has completely let down the citizens of this country, whose only avenue is a reasonable amount of discussion in Parliament before any law is brought into force. And unfortunately, even that opportunity was missed with regard to this year's finance bill, because after the budget, the Parliament, when it convened, I think from the early part of March, has hardly been functional. So there has been absolutely no opportunity for any debate with regard to this particular change, whereby the historical position that mutual fund investments, whether in the debt space, would qualify as a long-term capital asset if it was held for more than 3 years. That has now been upset by the change brought about by the finance bill, which will become the Finance Act.
Sir, why do you think this law has come about? Is it to normalize the whole tax incidence on investors, especially the fact that it's been used or misused by the industry and as an arbitrage product, and most of the investments have been on through large treasuries and high net worth and ultra high net worth individuals? Or is it something that the government is keen on rationalizing the whole tax process?
That's a very good question, Arjun. I think it's very important to give a holistic perspective and not take a very narrow and a very partial view on these matters. While I did say that the change upsets the position with regard to investors who have been looking to this product for a tax optimization, I would, at the same token, have to recognize the fact that arbitrages in the tax law is one form of inefficiency in the system. So wherever arbitrage opportunity exists in the tax law, they have to be smothered. And one such aspect has been the benefit which the mutual fund debt schemes were enjoying, essentially, let's say the growth schemes, over comparative products like a corporate or a bank fixed deposit or a direct investment in bond, creating an arbitrage and an advantage to funnel investments through a mutual fund route. So your question is absolutely right. There is definitely valid basis from a philosophical principle angle for improving the efficiency of the tax law. See, the tax law is efficient when it makes no distinction between different forms of income, when it makes no distinction between similar type of income earned in different ways, it is important that the tax law recognize only one fact, that people who earn more should pay more tax, people who earn less should pay lower tax. Beyond this differentiation, there should be no other arbitrary or artificial differences in the tax law by which some type of income enjoys certain exemption and other type of income do not enjoy. Because every form of income is in some sense finally dependent on the kind of risk, the tenure, and the various factors which are economic factors that determine the nature of the income. And the tax law should not make any such distinction. So to that extent, I feel that this was long overdue to rationalize the way of taxation of a similar income, which one earns either through mutual fund investment or through a corporate debt or a corporate FD or a bank FD. So I see this as something which was long required. So to that extent, it is fine. Though the manner in which suddenly it has been brought about, I think it deserves some more time frame for people to rearrange and rework their investment pattern. So that would be one very important aspect to be taken note of while appreciating this change. And we should not be only guided by the fact that there has been some detriment caused to the investors. The other point that you mentioned, very valid, is that maybe these debt schemes were being significantly accessed by large corporate treasuries who could clearly see an opportunity to get the benefit of long-term taxation, which is both the lower rate of tax as well as the indexation benefit, which is not available if you make direct investments into debt products. So by and large, I think the opportunity which the corporates were, to some extent, I will not call it an abuse or a misuse, but they were taking an undue advantage of this system. And that might get now sorted out by virtue of these changes. So I limit my answer to this at this point in time. If you have any further questions to trigger on this, please go ahead.